Welcome back to another week with Every Move Collective's Monday Masterminds. Thank you for being here to learn about estate and family planning with attorney Al Bernier. We know Al through a collaboration real estate industry group that we're a part of, and this event has been a long time coming. So really glad to have her here to talk about this. It's so funny. I feel like I've been talking to a lot of people lately and mentioning this call, and they're like, that's exactly what I've been telling myself I need to learn about, and this is perfect timing, and I'm really looking forward to hopping on. So that's kind of the space that we're in. And before I introduce Al more extensively, I just want to remind you of who we are. So myself, Colby, my mom, Eva, my brother, Dylan, who's on the call, we run a top producing team out of Westchester County, New York and Connecticut. We also run the amazing organization of Every Move Collective at eXp Realty, which brings you these bi-monthly masterminds. This is where we come together to learn, network, build community, share referrals. And we host these on the second and fourth Monday of every month. I will say, looking towards Q4, there's a lot of holiday conflicts and whatnot happening on those days. So we're actually going to shift to the first and third Mondays of Q4. So just a heads up, we'll remind you on our last call of Q3 as well, but so you know. But yeah, so we encourage you to be as conversational as possible. Use the chat, raise your hand, jump in wherever you have questions. Most importantly, turn your cameras on if you're able to. And if you can let us know in the chat right now where you're tuning in from, that would be helpful. Al, you're an attorney in New York, right?
White Plains, Westchester County is where my office is located. Colby.
Yeah, so we probably have a mixed room. I know Jean's in Florida. So just let us know in the chat where you're tuning in from. So
I have a couple of Californians here, I see.
Yeah, definitely. But anyway, Al, thank you so much for being here with us. Topic. I'm really eager to dive into this with you. As much as we may hate to face it, navigating asset allocation, the expenses of the passing of the loved one, and just preparing for all of that is just a really common human experience. And so we really appreciate you taking time to help us get informed on this topic. Al is a founding member of Bernier Law Firm. She graduated from St. John's School of Law, worked at various firms practicing exclusively as an estate planning and elder care attorney, and now she is assisting families with asset protection, estate tax planning, establishing trusts, wills, advance directives, as well as the probate process and long-term care planning process for elderly seniors. So I'm going to hand the mic over to her, and she can kind of give us a synopsis of how she got to where she is, and we can dive into the presentation.
Hi, thank you so much, Colby, for the warm introduction and welcome. Hi, everyone and all of our attendees. Thank you for coming. Today is a primer, a discussion on estate planning, legacy planning, and making sure we get our house in order. And about me, just like Colby said, I've been practicing exclusively as an estate planning and elder law attorney for 16 years since graduating from law school. And I truly can say that it is my passion, the work that I do. I love helping families plan for the future, making sure that their families, their children, their grandchildren are appropriately protected. And I always say that estate planning is the type of plan that you create to minimize disruption, chaos, and confusion. It's like your instruction on what you want should you have some sort of illness, disability, or if death happened. Having your instructions written in writing with witnesses and notarization, it's the strongest form of representation for you when you can't represent yourself and speak for yourself. So with no further ado, I guess I will start with the formal part of the presentation. Just note that I am a New York State licensed attorney, which means that the information that I'm providing is not legal advice. It's just educational. And a lot of the information is just going to be general, but it may have a skew or discussion on New York State specific. But estate planning is something that is jurisdictional. So wherever it is that you reside and you call your domicile, that's where you're going to have to seek counsel when it comes to estate planning. Thank you. And how do we do this? Share screen. Hey, everybody see the screen?
Yes, perfect.
All right, so it's a discussion on the importance of estate planning. Again, it's a primer. We're just making sure that everyone understands what estate planning is. So why should you plan? Like this is the intro that I love to start with, because I tell everyone that planning is important because preparation is key. You should do it. It's not that hard. It will give you peace of mind. Peace of mind is definitely what estate planning gives you. It gives you the comfortability and knowledge and the feeling that, look, if something happens where I'm not able to speak for myself, at least I know I have legal documents and I have chosen people that I have chosen to help represent me and assist me with what is needed. A lot of the reasons that come up when people tell me why they haven't done their estate planning is because I don't have the time. I'm not sure where to begin. Oh, I'm concerned. This is a big one. I'm concerned that if I plan my estate, that I'm inviting mortality, death, or illness, that it's kind of like a black omen. And having an attorney, it's expensive. That's another reason why people tell me there's been a delay in creating an estate plan, or it's just too complicated. You know, I'm here to tell you that don't let any of these reasons stop you from creating a plan. It's okay for you to reach out to attorneys. A lot of attorneys give complimentary consultations, so you can start understanding what it is that you need and what it takes for you to create an important estate plan. So don't delay. Here in the state of New York, but also, you know, statewide, countrywide, if you do not have a will or you do not have an estate plan, the state that you reside in, that you consider your domicile, they will write a will for you. And what does that mean? That means that you've passed away intestate, and because you have no will or a trust in place, there are bodies of law, but there is a body of law in the state that you reside in that will dictate who should inherit from you and who should be the decision maker when it comes to your assets and managing your financial affairs post your death. So here in New York, and it's likely that this applies to the rest of the country, that if you pass away without a will, the primary person that will have the authority to make decisions when it comes to your financial and property management affairs, such as if you have a house, right, and your name alone was on the house, or you had bank accounts and there were no beneficiaries on those accounts, or there's a lawsuit that was pending while you were alive and then you died, who's going to have the authority to continue prosecuting that lawsuit? It's going to be your spouse if you pass away and you have a spouse. The laws here in New York and most of the states here in the United States says, well, you didn't write a will, so this is who we decide that you would have wanted your affairs handled by, your spouse. And it doesn't matter if you and your spouse were separated for years, or maybe you didn't have a legal separation, you weren't living together. That's just a set of laws. Your spouse, we're deciding that you didn't write a will, so this is the person who should be a decision maker for you. And who should be inheriting, your spouse and your children if you have children. So sometimes in every family makeup and affair, it's not appropriate for your children to be a decision maker or your spouse to inherit from you. It really depends on it's a case-by-case analysis and your family makeup. For example, if your child is a spendthrift, or if your child does not have financial acumen, if you are survived by only one child and that child has issues when it comes to money, if you didn't create a will and you didn't create an estate plan, if the state says that that child has authority to manage your assets and your affairs post your death and to decide how it's distributed, then you don't want to pass away without having an estate plan in place. Similarly, if you have a child that is disabled, or maybe your spouse is disabled or receiving benefits, then that child or that spouse should not be a beneficiary under your estate, or that child or that spouse should not be a decision maker when it comes to your affairs. So it's very important for you to create an estate plan when you have these particular situations that arise within your family dynamic. Someone who is ill, someone who is a spendthrift, if you have a minor child, right? If you have a minor child and that child potentially could be inheriting several thousands or $100,000s should you and your spouse pass away unexpectedly. I mean, I don't know if everyone on this call read this article about a bunch of lawyers and investment bankers who were in Italy on a yacht, and there was just this freak storm that came, and the yacht, I guess turned over, and pretty much everyone, but save for 10 people, died. And it was husbands and wives leaving children without parents. And it was mom and a daughter, like a teenager or a daughter. So reading all of this, it was really heartbreaking that this freak storm happened out of nowhere. And my thought was, I really hope, that's the lawyer hat in me. I really hope that they had an estate plan in place when I read this article. If there were minor children who now do not have parents, we want to make sure that there's an estate plan that says the assets that these minor children are going to inherit are going to be managed by the person that I choose, and that those children will be inheriting at the appropriate time, not age 18, instead maybe 30 or 25 or 40. So doing nothing can leave your family in a very difficult situation, and there's no direction about what it is you want. So it's important to create an estate plan. So some of the key legal documents that I recommend to all of my clients and potential new clients are starting with a power of attorney and healthcare proxy. So what is a power of attorney? Right? A power of attorney is a legal document where you sign it, giving someone else, your agent, the ability to manage your financial affairs and your property management interests. So for example, if you need insurance payments to be made, if you have mortgage payments that are due on a monthly basis on your home, in the event you are ill and you are unable to make sure that your bills are paid timely, that your property taxes are paid timely, your power of attorney agent will have the authority to step into your shoes, to access your bank account, to make sure that those bills are paid. Another example that I like to give is if you have a sudden accident and you are hospitalized for a long-term period and you do not have the capacity to manage your financial affairs, what if there are certain benefits that you are entitled to as an employee of a company, such as disability benefits? I have disability insurance through my employer. Even if your employer was at your wedding and saw that you got married, if your spouse were to approach that employer to say, hey, Jane Doe is at the hospital right now, there was an accident, can I fill out an application for disability for her? Because I know that the company offers disability insurance. The employer will have to tell you, well, I know that you are the spouse, I was at your wedding, but unfortunately, without a power of attorney signed by Jane Doe, your wife, I will not be able to communicate with you. I will not be able to allow you to sign off on important forms and applications. When it comes to health insurance and benefits, there are time restrictions on these applications, and you can't help your spouse with respect to these applications. So that's one example why a power of attorney is important. Another example that I give is every April 15th, we know what comes up, right? Every year, we have to make sure that our income taxes are filed and paid. And if they're not filed and they're not paid, there's going to be what? Interest, there's going to be penalties if you're not timely. And the only person that has the authority to sign off on income tax returns on your behalf is clearly your power of attorney agent. So I always say that a power of attorney is probably one of the most important legal documents that you can sign when it comes to your estate planning, because your power of attorney, if properly drafted, can actually create trusts on your behalf. They can actually do tax savings mechanisms on your behalf. So when it comes to all of the bevy of documents that I describe to clients, I frequently say that a power of attorney having a comprehensive, well-written power of attorney is the most important estate planning document that you can sign while you were living. Healthcare proxy, that's a medical document, right? This document is where you indicate who you would like to make medical decisions on your behalf should you become sick or ill and you cannot speak for yourself. We all know here in the United States, when it comes to healthcare, it's important to have an advocate, someone who is standing there by your bedside to communicate on your behalf. So having a healthcare proxy written that indicates this is who I want to be in charge. And if this person's not able to make decisions, then I want X, Y to be the backup is important. You know, I like to point out this story. I had a client and she's an elderly woman and she had 3 sons. And out of the 3 sons, one son was the one that was there. He took her to her doctor's appointments. He was managing the finance. He was her right hand. But in confidence, she told me he's not the proper person to be my healthcare proxy. And I said, well, tell me why. He's taking you to all your doctor's appointments. He knows what medications you take, X, Y, Z. She said, no. When it comes to emotions and like trauma, like if you're hospitalized and there's an emergency, he's going to freak out. My other son, who is an MD, he's more appropriate. He's going to be able to speak the language that is needed when it comes to dealing with social workers, doctors, nurses. So creating an estate plan is important so that it's clear who is going to be able to make decisions and what the hierarchy is for healthcare decisions. Another document that is considered a medical document is a living will. It shouldn't be confused with a last will and testament. The living will indicates what your wishes are when it comes to end of life treatment. So if you have specific instructions about not wanting to be kept alive, if you're a vegetable, or if you have no brain activity, that you would prefer to have maximum pain relief and that the plug should be pulled, then having a living will indicating what your express wishes are important. Whenever I talk about a living will, I talk about the Terry Schiavo situation that occurred in Florida. There was a battle between the mother and father of a young woman who had a sudden onset of a disability that left her in a coma or a vegetative state. Her spouse did not, I'm not sure of the exact facts, but either her spouse or her parents did not want her to stay in this vegetative state, whereas one side wanted her to be kept alive. So there was a battle in the courts, and it was very sad. When I bring up this situation, if you have any specific wishes with respect to what you want when it comes to end of life treatment and care, having a living will is important because that is going to speak for you despite your inability to do so for yourself. And of course, arranging and pre-arranging any wishes with respect to funeral services. That's another legal document you can put together. If you have any thoughts about organ donation, cremation, burial, having it reduced to writing in a funeral and burial designation document is helpful. And it helps your family because they're not guessing. They know what your wishes are. And of course, last will and testament, right? A last will and testament, that's a legal document. This document is going to indicate how it is that you want your assets distributed at death and who it is that you would want to be in charge of the process of managing this distribution of your assets and paying your bills, right? The last will and testament is where you nominate an executor, the decision maker on distributing assets and paying bills, and you indicate who your beneficiaries are. Having a last will and testament is important, like I said, because it eliminates confusion. For any of my parents who are on the call, if you have minor children, having a last will and testament is key because it is in this document that you will be indicating who should be the guardian of your minor children, should there be a death, a sudden death or on your part and on the part of your spouse. And not to say that the will is going to be the automatic per se document that says, yes, my sister will be the guardian for my minor child. It is just presumptive, and it's evidence of what your wishes are. Of course, that chosen person is going to have to file a proceeding to say, I would like to be the custodian, the guardian of this child who now has no parents. And having the will that has been witnessed and notarized is indication, it's an indicia, it's an evidence of who should be preferred to be the guardian. Beneficiary designations. This is an important part of estate planning. I can't tell you in my 16 years of practice how many times I have met with clients who created a will 10 years ago, 15 years ago, or 20 years ago. And in that will, it says that I leave all of my assets to my mom, and they have been married or had children, or I leave all of my access to my wife, and she shall be the executor of my estate. But they were divorced, 5 years ago, but never failed to update that will. Estate planning is important. It's a document, and documents that should be reviewed and updated every 3 to 5 years. Such similarly for your beneficiary designations. You want to make sure that your beneficiary designations on your contract accounts, such as your 401ks, your annuities, your 403bs, your brokerage accounts, right? Those brokerage accounts, you can have a beneficiary on there. You want to make sure it aligns with your current wishes, as well as it aligning with your estate plan. All right. When you have beneficiary designations on life insurance, retirement accounts, annuities, those assets escape probate. Probate is the process of having a will submitted to a court for that will to be approved, in order for assets that do not have beneficiaries to be marshaled, collected, and distributed or sold. For example, a house. If your house is in your name alone, should you pass away, that home will fall into probate. Now, how do we avoid probate? By having beneficiaries on the account, or by having that home, which I gave you an example of, in a trust. And I always say that creating trusts are so great. It's flexible. It is the pathway to legacy protection planning and creating generational wealth. So what is a trust? It's a legal arrangement between the trust creator, the beneficiaries, and the person you have chosen to manage those assets. If your home is titled in the trust prior to your passing, your home will escape the probate process. So a big part of my practice is working with clients to frequently make sure that we avoid probate. Why do we want to avoid probate? It's because of the delay that probate presents, at least in New York State, as well as making sure it's a private arrangement. When there is probate, probate is a public process. Information that is submitted to the probate court in terms of who beneficiaries are, the will, who the executor is, the beneficiary's address is public. And if I want that information private and I don't want it to be part of the public purview, having a trust can help protect and keep information private. And it also avoids the delay that also ensues when it comes to probate. So back to trusts. Trusts are very flexible tools. They can be revocable or irrevocable. It really depends on your particular family structure, the assets that you have, to determine what is the appropriate structure for you. A revocable trust, just to be very brief, can be changed at any time while you're alive. You can make decisions with respect to what assets go into or out of that trust. There's so much flexibility. You can be in charge of the assets that are in a revocable trust. An irrevocable trust typically cannot be changed. And as well, you're not in charge of those trust assets. Some clients ask me, why would I create a trust? What's the importance if I can't be in charge of those assets? Well, it really depends, like I said. on the particular family structure and the assets that you have. There are certain reasons you create a trust. If your assets and the aggregate of your assets are extremely high, and we want to make sure we minimize the taxes that can ensue upon your death, should your assets aggregate to a certain threshold, these are called estate taxes, we can restructure your assets into certain trusts to minimize the estate tax that would be due. When there are estate taxes due, it minimizes the amount that your beneficiaries, your charities, chosen charities will receive. So planning in advance helps to minimize certain tax liabilities. For example, if you have a child, like I had said, that has a penchant for spending, if you have a child that doesn't have financial acumen, having their inheritance protected in an inheritance protection trust can shield those assets from creditors, from people who are trying to get access to that child, to get access to those funds. And of course, if there are any beneficiaries in your estate or in your family makeup that you want to benefit or enrich their lives, if they're disabled, you don't want to leave an inheritance to them, because doing so might frustrate their ability to get important benefits. There are benefits that are important for clients who have disabilities such as muscular dystrophy, all these different disabilities that present themselves. It doesn't matter, at least in my experience here in the state of New York, if your family has extreme wealth, having them qualify for certain benefits is the gateway for them to have access to programs that will enrich their lives in terms of working in a setting that is recognizing that they have certain disabilities. I always say that the Medicaid program here in New York is the gateway for certain sects of the population for them to get help so that they can live a gainfully employed life despite the fact that they have their disability. And having a trust fund set up for that child can help enrich that child's life and help pay for things that aren't available or paid for through these different benefits programs. So there are myriad reasons why a trust should be created. It's going to be a discussion that you're going to have with your attorney. I always say full disclosure is important so that the attorney can guide you in terms of what's best. So types of trust, I kind of touched upon with the types of trust that are trusts that I frequently recommend for my clients. One is an inheritance protection trust. This is a trust fund that is important, also known as like a minors trust for our children. If you have children that are minors and you don't believe that they are financially savvy enough to benefit from funds. So for example, if I've met with clients and they tell me, look, I have a 24 and a 23-year-old. That 24 and 23-year-old, I don't think that they should be receiving funds should I pass away tomorrow. When you create an estate plan, you're creating an estate plan to under the hypothetical that tomorrow or next week, I'm going to pass away or there's a disability. You're planning for the future. And if at that time you don't think that your child should be receiving funds or any beneficiary that you have should not be receiving a large sum of cash, an inheritance protection trust can help stage the amount of money they receive and the time they receive those funds. And same thing with the spendthrift or a safe trust. It helps guards those assets to ensure that they are protected from a beneficiary's penchant for spending, substance abuse, or their inability to understand what it takes to invest money. Medicaid Asset Protection Trust. This is a big tool used in my elder law practice for my clients who are much older. They have a modest estate, and they may have had a home that they bought for $30,000 back in 1970, but today that home is worth $1.4 million, and that's a real deal situation here in New York. I have a client now, she is very house rich. Her home is worth $1.4 million in Forest Hills, New York, and she has a modest estate, just a couple of 401ks, inherited IRAs and an IRA for herself. And the concern is, how are we going to keep her in her home despite the fact that she had a stroke 7 months ago? So in that instance, what we're doing is we're looking to move assets in the future into different types of trusts to qualify them for Medicaid in the future. Special needs and supplemental needs trusts. These are the special types of trusts that you create for beneficiaries that are disabled and that are reliant on certain benefits program due to their disability. And creating a trust can enrich their lives to ensure that certain benefits that they're receiving aren't disqualified or terminated. And the trust can help buy extra things for them, such as iPads, therapeutic treatment that's not covered by their standard health insurance. So these are the various types of trusts. There are more out there. I just wanted to touch base on a couple of them. So when is it a good time to review your estate plan? I always say that every 3 to 5 years is the time frame for you to pull out your estate plan, review it, make sure that your beneficiaries and your fiduciaries align with what your mind is presently at. If you've moved to a new state, you've gotten married, birth of a new child, grandchild, adoption, when you retire, you should be looking at your estate plan, divorce, right, to see what updates are needed and what you should be doing. If you were to come into a windfall, if you inherited money recently, look at your estate plan to see what needs to be restructured and what needs to be recreated. Here are
I
some
have a
comments.
quick question there, actually.
Go ahead.
So I'm sure the answer is kind of there's no time too soon, but at what age do you recommend really starting to take a serious look at that? If you're, maybe in your 20s or 30s, like, do you find that people wait too long?
So I can say in my practice, I do see that estate planning is a type of plan that is more motivated and created frequently amongst my clients who are 55 and up. At that age, there is more of a thought process about, I have children, I have older children, grandchildren in the picture. I'm about to retire, or I am retired, and now is the time for me to start thinking about this. Maybe because their jobs are having them fill out forms talking about Medicare, or other family members are indicating, well, this is the time for you to create this plan. But it's definitely too late when you hit that stage. You should have had an estate plan in place at least by the time you got married. If you had children, you should have had an estate plan in place so that you nominate a guardian for your child as soon as you give birth. Yeah, right. Like, I remember when I was about to give birth, I started thinking so much about something happening to me. And I wanted to make sure that my precious daughter would have something. So of course I ran and got life insurance, right? It was a time where in the news, a lot of Black mothers were dying, giving birth. So that was something that was heavy on my mind. So I got life insurance, but I also created a trust fund for her to make sure that the life insurance pooled into that trust fund so that it can enhance her life, albeit without me being there. So your question, Colby, about when is the opportune time for people to create an estate plan, I definitely think that once you get married, you make these pivotal moments in your life, having a comprehensive estate plan, or you move to a new state and you started a new job and now you're starting to work, and you want to make sure there are documents that are speaking for you. These documents are helpful. Another reason why 18-year-old, which is another reason, another age, a threshold, should be signing up at least at a minimum a power of attorney and a healthcare proxy is if that 18-year-old now is going away to Colorado, California, and the parents are here in Florida, New York, or Connecticut. Or even if they're just an hour or two away, that 18-year-old should have a healthcare proxy indicating that mom or dad, I want these people to make medical decisions and to speak with doctors. At the age of 18, the wonderful United States determines that you're an adult. right? You can go serve in the army, you can go serve in war, and you can make your own financial decisions and your own medical decisions. But we all know on this call that at age 18, not all 18-year-olds are mature enough to make these decisions. And of course, if there's a disability, we want there to be someone there to help them. I can tell you that my own sister, in her senior year of college, she contracted, what do you call that? Meningitis in college. And I could tell you, like, those 2 weeks of when she was out of it, she didn't know who the president was. It was a horrifying time for my family. So estate planning is important because she's considered an adult, right? How do parents get access to medical records and make medical decisions? She's a senior in college, having a healthcare proxy. So when your child and you're packing up the dorm and you're getting all the books, part of the plan is call your lawyer to have your adult child who's 18 come in and sign a healthcare proxy and a power of attorney. So that's estate planning, even for an 18-year-old. And the power of attorney for that 18-year-old in favor of the parents allows the parents to get the grades, because you can maybe paying the tuition bill, but the university will not release the grades to you without permission from the child. So we need certain documents in place. If I'm paying your tuition, and we know tuition's expensive now, I need those grades.
I'm gonna jump in here, Al, on that one. My rule was if I'm paying the tuition, I get the info, or you can pay the tuition. But that aside, seriously, one of the things that I struggled with, I'm embarrassed to say, we didn't do a will very early on, because we had trouble like deciding who we wanted to take care of our kids, in the event of us passing. Do you run into that kind of thing? And do you have any recommendations on, I mean, I guess it's out of the scope of the legal aspect of it, but how do people help rein that in a little bit if they're struggling with that?
Absolutely. Great question, Eva. And I have to tell you, I have had clients that struggled with that. And that was a delay, especially if it's, partner and partner, spouse and spouse trying to make a decision. Well, I would like my sister. Well, I would like my sister. So this is the advice that I have given clients over the years. I have indicated, well, the person that you're looking to be the guardian, think about if you and your husband or you and your partner passed away next week. How old is your child? Where does this guardian live? Does this guardian live across the country, or the person amongst your pool of people live in the same state? Do they share the same values as you? If you're religious, if you would like your child to continue being brought up in that faith, you want to make sure that that person out of the pool of people have the same faith, because at least you hope that they will continue with that rearing. If that person is in the same neighborhood as you, the same school district, God forbid you pass away and you and your partner pass away, that child is dealing with enough now to be uprooted. Now they're moving across the state to go with the chosen guardian, whereas I have someone within my pool of chosen guardians who is in the same town, the same school district. So my child's life really won't be disrupted that much, aside from the fact that there's a loss of a parent. So that is one way that I have helped my clients make a decision when it comes to trying to choose a guardian. Of course, finances, right? The guardian is going to be managing some certain financial portions of that child's life, making expenditures, decision about when they can drive, choice of school education. I want to make sure that that person has a good head on their shoulders, and they've been managing things for themselves appropriately. And if I'm not there, if I like the style that they have for teaching, for raising their children, or the way we were raised, then that would be a good choice. I hope that answered your question, Eva.
Yes, absolutely. Thank you. So I didn't mean to derail you there.
No, it's fine. I think, I'm pretty much wrapped up. Here are some common mistakes in estate planning. The mistakes that I have seen over the years is when you are meeting with your attorney and you do not disclose all the information necessary so they can properly plan for you. Choosing an agent, a power of attorney, or a trustee or an executor that's inappropriate. And I think that speaks to your question, Eva. How do you make the right choices? And I have done a presentation on how do I select the appropriate executor. And one example that I give that might bring a chuckle is, look, if you go out to the dinner and your friend is running out on the bill every time, right? You know, it's time for us to pay and they forget to Zelle you their portion of the bill. I don't know if you should be my guardian, my executor, or my trustee, right? If you know that person is living check to check, as an example, like, right, they don't manage money appropriately. They should not be your executor or your trustee. Failing to align your designations on your 401ks, your insurance, your brokerage accounts with your estate plan. If your will says, I leave everything, I love you, honey, to your spouse, your wife, but then your IRA leaves everything to your mom, and then your life insurance leaves everything to your mom, then what's the point? You have to make sure you speak with your attorney, and your attorney is competent enough to make sure that your estate planning make sure that your beneficiary designation aligns with your estate plan. Failing to account for digital assets, right? A lot of us do a lot of online banking. We have online investments. You want to make sure that the people that you're choosing to make decisions for you post your death or in the event you're disabled has a comprehensive document. It's called a letter of instruction. And this letter of instruction is going to outline what your assets are. It's going to outline where your accounts are. I have an account at Chase. I have a credit card with American Express. This document is going to speak for you should you have some sort of disability, and you want this document to your agent to have access to it so that they know, well, you know, Mary Jane has accounts at Chase, Bank of America, and Merrill Lynch. She also has a homeowner's insurance policy with Cincinnati Bank.
Is the letter of instruction part of the trust, or is it part of the healthcare proxy, or is it just an envelope above all of it?
Yeah, the letter of instruction, or shall I say final instruction document, is separate from your will, your trust. It's part of your estate plan. That's a document that I provide to my clients, and I instruct them. I tell them, look, it's for me, it's about 4 pages long. And in that document, you're going to put your social security number. You're going to put your mother's maiden name. You're going to put your address. You're going to put who your homeowner's insurance is. Because if you're disabled, you want that premium paid. You're going to put who your car insurance insurer is. You're going to put, these are my 4 credit cards, right? Chase, Visa, Amex. This is my financial advisor, name, email, phone number. This is my lawyer. On my form, my name is already inputted on that document, right? So that document is either provided to your chosen agent. And if you're not providing it to them, you're at least letting the agent know, look, I have a safe box in a lockbox in my room. It's in the 2nd floor in the top of the closet. The keys are located in XYZ location. Something happens, go into that safe box. You're going to have this letter instructing them. So they're not in a frenzy. They know where to go to access documents. My will is X. My trust is and why.
My aunt used to work for the Salvation Army, and they used to find quite a few treasures in the pockets and pocketbooks of pants and jackets and purses. And that, what you're talking about right there, eliminates that probably quite a bit, right?
Absolutely. And I have to tell you, I do have people in my family, or my very close family structure, that as I was growing up as a little girl, look, this, and go into this dress because I have, cash money just in case there's an emergency for you to access. So
I still wonder about that. My dad passed away 4 years ago, and he was that kind of a guy who like probably had something tucked somewhere. I still wonder if there was something. Hey, I just wanted to ask another question that may be pertinent to everybody here, or that I wasn't aware of until pretty recently, and that's my business accounts. I wasn't aware until pretty recently that I couldn't put beneficiaries on my business banking accounts. So outside of a trust or a will, is there any other recommendation that you have about your business, about people's business accounts?
Yeah, absolutely. For my clients that have businesses, depending upon how they are incorporated, maybe it's an corporation, maybe it's an LLC, we want to make sure that the operating agreement, that the agreement that operates to manage that business indicates, should I pass away, I've assigned the shares of this business to my trust, so that your trustee, your successor trustee, has the ability to continue managing those assets post your disability. So your estate plan should absolutely align with the fact that you have a business. And of course, you need a power of attorney. You want the power of attorney to be comprehensive, that says, look, if I'm disabled or I'm incapacitated, I'm unable to access my business accounts, my power of attorney, which is all encompasses, allows X agent to access that business account.
Thank you. One other point, and of course, I'm not asking you to get into any detail or disclose, fees specifically, but you started off early on saying that, one of the reasons why people don't do this is because they think it's too expensive. Can you give a sense of, is this like a $20,000 project? Is this like is it, define very expensive, I guess, in the best way you can?
Right. I mean, it really depends on what the client's finances are, their assets, what their particular estate plan requires based on their particular needs. If there's minimal assets, right? Of course, your estate plan shouldn't be $20,000. If you have just a house and a couple of bank accounts and a 401k, I don't see why your estate plan should be more than 10K. It could be less
So
than that.
it's all relative. Like somebody should say, just because I don't have a lot of assets to protect, that's not a good reason not to protect it because it's all relative. Is that fair
Right.
to say?
Yeah, it is fair to say. But then if we have assets and we're now considering estate tax planning, right? Because here in the state of New York, there is an estate tax. If you pass away and the aggregate assets in your estate exceed $6.9 million approximately, an estate tax is triggered. And like I said, that is less for your beneficiaries or your chosen charities to receive. If you want to try to minimize or avoid that estate tax, there's planning that you can do by restructuring your assets into certain trusts. So here's the thing. If we're doing advanced planning like that, it's not going to be $2,000, right? Expect that you're going to be spending some money, right? If we're saving your estate hundreds and hundreds of thousands of dollars, there's going to have to be a bill to for that lawyer's expertise. So it's all relative, like you said, Eva.
Excellent. Is there anybody here who wants to hop in? I don't want to monopolize the conversation. If anybody has any questions, please
We've
don't
got a
hesitate.
chat question.
Oh, we did? I didn't.
I'm going to stop sharing now.
Yeah, that's cool. Yeah, Karen just asked me if there's any written materials covering what you discussed this afternoon. We will share a replay of this with everyone who attended, so you can rewatch it, retake notes, whatever works for you. But Al, if you have anything that you would want us to distribute to people, we can definitely do that.
Like if there's a worksheet that you give to people when they're considering working with you, and if you think that would be advantageous to anybody, yourself included, we'd be happy to share it. So, any way that we can put people in touch with Al, for more detailed information, we're happy to do that as well.
I've got a question that I don't think that we really quite touched on, although maybe we danced around it a little. One of the things that we had mentioned in our marketing around this was how do we actually start a conversation with older parents about estate planning? Like that's a hard some people, like you mentioned really early on, like some people are really averse to this. So how do we help them have difficult conversations around this stuff? Especially, and also with, a lot of the people here are realtors. How do realtors encourage their clients and really empower their clients to do this for themselves as well? Like, how can we be a resource to get our clients to make good choices when they're acquiring assets?
I think as realtors, definitely when a case is closed, right? House sold, which is always the most joyous moment for a home buyer, like a first-time home buyer, second home buyer. If it's a couple, if there's someone who has young children, or if it's a single parent, or maybe it's just a new homeowner working and they're single. These people should have estate plannings. They should have estate planning documents. And you could indicate, look, you just closed. Great, congratulations. Make sure that these things are checked off on your list in terms of housekeeping. You want to make sure you're looking into, I remember for me, when we purchased our first home, there was something, insurance for appliances you can get if your appliances break. Right? The real estate broker was very good with making sure she gave us some things that were helpful. I think it's important for you to say, look, get your estate planning in order. You have a home now, it's a really large asset, and you want to protect it. And you want to make sure the person you want to benefit from this home, should you no longer be with us, receive it. So that's one way that realtors can start the conversation. Another way for anyone on this call, aside from being a realtor, to introduce the conversation to adult parents. I'm an adult child. I have older parents. They may be very independent. They may be handling all of their affairs on their own. It's very difficult for an adult parent to receive the information from their adult child, because I don't care, you're 35, 40, you're still my child, right? But giving them the business card of an elder care attorney or a estate planning attorney, and to say, look, I had a coworker that went through this with their parent, and there was no estate planning in place. Dad, unfortunately, had a stroke, and they had to go to guardianship court. Because that's what happens if there is a sudden illness and you're not able to communicate for yourself. Your children or your chosen people can't manage your finances. And the only way that they're able to do so is by asking a judge through guardianship proceeding for authority to manage finances. And it's a very intrusive process. You want to avoid it like the plague. So letting your adult parent know, I know that this is a touchy subject. Here is the contact information for a lawyer that you can speak with, and let the lawyer have that conversation one-on-one, because it may be difficult for the parent to speak about it with the adult child. But having that conversation with an independent party, an independent professional, is helpful.
I know we're getting close to the end here. I just want to ask a question that's not really exactly related, but I, as a realtor, have come across attorneys reaching out to me and asking me to give them a market analysis for a certain date. And that date has to do with when somebody passed away. And they're evaluating value so that there's less tax for, the difference.
Mm-hmm.
Does the trust change any of that, or is that still kind of, that has nothing to do with the?
No, the trust does not affect the date of death valuation of assets. What the trust does, it allows for a continuity of asset management. So I like to give this example. There's a death and there's real estate. For the New Yorkers on the call, we have seen the uprise of squatters going into home, claiming there's a lease, taking over property. And it's happening because for a large part of the times, that real estate is vacant because it's caught up in probate. We're waiting for a judge to approve a will to give beneficiaries or executors the authority to move forward with a sale. And what's happening during that time frame? We have squatters, we have that property that's vacant, it's subject to waste, it's subject to having frozen pipes. So a trust protects property, and it ensures that that property is managed post your disability, post your illness, and post your death. It avoids probate completely. There's no need for that home to wait for there to be a sale for an executor to be appointed. That trustee that's named in the trust document will have the ability on the day after you pass away to enter into a contract of sale, to go through with probate. So having a date of death valuation to ensure what that what that value of that property is as of that person's passing has nothing to do with the trust. Appraisals are important. It's an important tool to establish what beneficiaries inherit property as of the date of death of a passing of a homeowner.
Thank you.
Thank you. Yeah, I just want to make a statement. My name is Keith. I'm a client of Attorney Bernier, and I had a previous lawyer to make a will for my mother-in-law, and he was a general lawyer. And not saying that they don't do as well as a estate planner, but when I went back to ask him a question, he said we would just go into probate. So I think when you talked about price, when you consider going through the court, you're paying for that. If you have a house, you're going to have to pay for the mortgage until probate is completed. Whereas if you go to an estate planner, they know how to customize everything to prevent all those costs. So in actuality, what you pay up front, you save on the back end. So I was very appreciative for the consultation that we received on a second time, and to really see the difference, which really customize our trust fund. And it does really make you feel much more relaxed, especially when you go on a vacation, you go on a plane ride, or you're separated for your kids. If something happened, you know that your kids are in good hands. So thank you, Attorney Bernier.
Thank you, Keith. We appreciate the contribution. Anybody else? Questions or?
You got one question from Marie in the chat. Is a payable on death a good idea for putting it on a checking account? Can it be put on other accounts?
Absolutely. Payable on death is a beneficiary designation that you can put on bank accounts. But don't make the mistake of making the account payable on death to a minor. Like I want these accounts to go to my grandkids. I've had clients do that, right? These are for my grandkids, or these are for my kids, but those kids are minors. That money will not be payable to them on your death if they're a minor. What's happening is the child who now has inherited a sum of money, their parent or their legal guardian is going to have to go to court to file a petition to be established as that child's guardian to get and collect those assets. And those assets won't be distributed to the minor or to the parent. It'll be held in joint control with the court until that minor hits 18. So in certain situations, PODs are great, right? But what if that person you're making the account payable on death for, they receive $100,000 from this checking or savings account, but your will says, I want all 3 kids to inherit equally. Well, that $100,000 that one child received, can you expect or rely that they will share those proceeds with the other children? We hope so, but we never know what the future holds. And I have had clients tell me, look, I know my son will never do that, but what if that child enters into a financial situation that's stressful? The likelihood is he may want to use those funds for his financial situation versus sharing with the other siblings. That's just one particular reasons why payable on death is good, but it depends on what your estate plan is.
Thank you.
Al.
Yeah.
If there's, I think maybe we're kind of nearing the end here, so maybe we don't have time for any more questions. But Al, if you're comfortable with us sharing your information, people, especially in New York, can reach out to you and talk to you maybe in a little bit of a more personal time frame about things that they're dealing with in their own, world. So
absolutely. I'll share it in the chat and you can share my information. Like I said, I'm located in downtown White Plains, Westchester County. I'm happy to make sure that information is appropriately received by everyone. Thank you for joining.
Thank you so much. And I just really quickly, we actually have another collab member coming on as our guest speaker for our next call in 2 weeks, Monday, September 23rd. We're going to be talking about LinkedIn and how you can really leverage this platform to the highest degree for your business. So I shared the RSVP link in the chat. Please join us. It's going to be a great call. And again, I'll send around an email afterwards with the recording and everything that you need to rewatch and learn and implement all the things that Al shared with us today.
I just put my contact info in the chat as well.
Perfect. I'm going to copy and paste that as well so I can send it around in the email. But thanks everyone for being here today. Really appreciate it. Thank you so much, Al.
Thank you.
Bye,
Everybody
Nick.
have a fabulous day.
Hello, hello. Lovely to see you all.
Yeah,
Thank
thanks
you,
for
guys.
joining us.
Hi, Nick. Nice for jumping in.
No, thank you for having. Pleasure. I'm sorry I was running a bit late, but great to see you guys.
I received your card. That was
I'm
sweet.
glad. I'm glad.
Thank you.
No, thank you guys again. Have
See
a
you
wonderful
soon.
rest of your week, guys.
Everybody, have a
Speak
wonderful
soon.
day, wonderful week. Make it a great one. See ya.
Bye.